Hi, welcome to Pennsylvanians for Modern Courts programming on the courts and the legal system. I am Deborah Gross, PMC's CEO. I would like to thank you for being with us today. Our programs are designed to help you understand the importance of the courts, their impact on you, and their fundamental contribution to our democracy. Our goal is to provide you with resources to navigate the courts with confidence and understand your rights. After a long career in private legal practice as a litigator and as a passionate advocate for the nonprofit legal community, I pivoted to advocate for increased awareness about and access to the courts. Judicial independence is the cornerstone of our democracy, and the public's attitude towards and confidence in the judiciary has shifted in recent years. We hope these programs help you understand that judicial decisions are made based on Constitution, statutes, and the law, and not public opinion. Please visit our website, www.pmconline, that's Paul, Mary, Catherine, to learn more about PMC and find an abundance of resources on the courts. Thank you for listening, and let's begin tonight's program.
Specifically, as I said, it's legal order from the common pleas judge. Right now, Judge Rango, she's the administrative judge of the criminal court. So it can be for an arrest which did not result in a conviction, an arrest which resulted in ARD or PWD, which I'll talk about, I think, a little more in a minute. A juvenile arrest record in most cases. Partial expungement, so an expungement can be for everything related to a case, or it can be for whichever charges you were not found guilty of, or were dismissed or drawn against you. And then summary convictions, which we, I guess I can talk a little bit about that right now. In Pennsylvania, there are pretty much three classes of offenses. There's felonies, which are the most serious, misdemeanors, which are kind of the intermediate, and then summary convictions are not actually criminal convictions. I always tell my clients they're kind of on par with like traffic tickets. They're kind of treated in a similar vein. The maximum penalty is 3 months in jail. Whereas for misdemeanors, it starts kind of at a year. So summary offenses are treated a little differently. Any summary conviction can be expunged as long as you go at least 5 years with no arrests or prosecutions. And then any misdemeanors and felonies which aren't subject to expungement, anything you can go to the governor's office, you can apply to the Board of Pardons for a pardon on. Those are pretty difficult to get just because of the volume that they see. So that it's pretty selective in terms of how often those are given out. And then ARD has a few specific rules. Just as an overview, ARD is basically for first-time offenders. There are specific charges that they usually let in there. And I always tell people it's kind of where you do the sentence first. PWD is the same for first-time drug offenders. You kind of do your sentence first, and if you complete it successfully, then rather than having a conviction, they will dismiss the charge against you and keep your record. So that's what those two are about. So why are they important? Yes, I agree with all this. People make mistakes and shouldn't have to pay for them for the rest of their lives. The justice system is supposed to ensure punishment commensurate with the crime, and sometimes for some of these offenses, one of the things that hasn't historically always been taken into account are collateral consequences. Are, you know, you did something when you were young and it kind of follows you for decades of your life. So one of the main goals of the Sentencing Commission is for rehabilitation, and so expungements and sealing of records is kind of part of that, and that's kind of part of the reason that's listed in the statutes that describe expungements and sealing. So obviously, I think the primary reason for an expungement, the most significant one for the clients that I deal with, would be for employment purposes, also for housing purposes. Those can affect certain programs that you're available for. Obviously, employers are often interested in your background in terms of your criminal history. So those are certainly at least the most common reasons. There are a myriad of reasons why it may be important to try and get your record expunged anything that you're eligible to do or get it sealed. So this is a little bit of the law, which I won't bore you too much with, but the specifics here go over the main ways to get expungements. Again, the biggest one, volume-wise, that the two biggest ones that we tend to see are if you have a charge, you were never convicted of a charge, so that was withdrawn by the government, if it was dismissed by a judge, if you were found not guilty at a trial by a judge or a jury, or it's not process, basically, it's just the Commonwealth saying we're likely not to proceed any longer. The other one that's the most common would be summary convictions, where you've gone at least 5 years without an arrest or prosecution. The case law says basically that can be any 5 years. So even if you get a lot of summaries, like every 2 years or so, if you then go 5 years after the final one, you can get any of those prior expunged. Some of the less common ones that technically are eligible, and then diversion programs, I kind of count that in the non-conviction because you come out of that successfully without an actual conviction on the record. So one thing that I think people don't often realize is that if you are 70 years of age and you go 10 years, this I think actually is a type of summary conviction. If you're 70 and you go 10 years without any sort of conviction, you can get even a felony expunged. That's really the only way you can get a felony expunged in Pennsylvania, other than a pardon. And misdemeanors, again, typically aren't eligible. Misdemeanors, there is one misdemeanor which is always eligible if you meet certain requirements, which is underage drinking. That is the other misdemeanor that can be eligible for these substitute. So that's kind of the law over expungements. Bless you. Yes, here we go. So 1821. You can go. So this kind of goes over that. This first one, I'm just going to skip because it confuses me, and I think it's a little duplicative. The second one talks about underage drinking, summary that's 75 years, and then ARD or kind of PWB falls in this, which is just basically you complete your probation and then you just don't have a conviction afterwards. So these are the types of expungements. This limited access is kind of the ceiling thing we were talking about before, and this is kind of significant for what my office does, because you can have a full expungement, which is every single charge that you were charged with was either dismissed or you were found not guilty. A partial expungement would be if you were found guilty of some of those charges, but not all of them, then any you were found not guilty of, you're going to have expunged. So if someone were to look at that docket, if you originally had 5 charges and you were only found guilty of 1, that's the only one that would show up. Limited access is sealing your criminal history for the ones that are eligible, and we're going to have slides that specifically talk about that near the end. Summary charges, as I said, those kind of non-criminal things like disorderly conduct, sometimes harassment, sometimes retail thefts for low amounts, those sorts of things. If you go 5 years without an arrest or prosecution, you can get those expunged off your record. And then for ARD and for ARD at least, the expungement process is automatic. So that's one where you wouldn't even really have to file anything as long as you successfully complete ARD. So partial expungement, again, some charges were convictions and others were dismissed. They can expunge any of the charges which you were not actually convicted of. No, I mean, I always tell people if you wait until the end of your case, then we can take care of everything at once. But as soon as charges are dismissed, you're entitled to file something. The law has changed recently where typically nowadays, once something gets dismissed, if you have a hearing at a magistrate's office and only certain charges get held for downtown, I found that the dockets nowadays usually reflect that. They automatically kind of take those ones off that were not held for court for common police court. So that can happen without you having to file anything. If there is an oversight and it hasn't been taken care of, you can get a partial expungement at any point in the process. But obviously, if your case gets fully expunged at the end, or if everything is dismissed at the end of your case, then you could have a full expungement. So if you wait till the end of the process, you might only have to file one petition rather than two, but legally you can file a partial as soon as there's any dismissals. And again, full expungement is just any case where every charge that you were charged with was either dismissed, withdrawn, or so limited access expungement, that is kind of the ceiling or the clean slate, that's what you might hear it called. Basically, the courts operate off two dockets. There are the one that is accessible for anyone, that any of us can go look up the general court docket, type in someone's name or case number. The courts themselves have a limited access docket, which only they and other criminal agencies have access to. And so when something is sealed or subject to clean slate, it will go on to that limited access docket. So all those people I said before, the DA's office, the state police, the magistrate's offices, they may still be able to access that information, but the law shields in most cases any other entities from seeing it, any public entities, which can include employers, people looking at it for landlords for housing purposes. You know, there's some limited exceptions, I think the slides cover later, but that's generally the difference between expungement and sealing. Is that expungement, it's destroyed for everybody. Sealing, criminal justice agencies still have access to it, but the public in general does not. And this kind of talks about some specifics that we're going to get into later on the slides about what types of charges are eligible for sealing. So summary charges.
Oh, I'm sorry.
So summary charges, again, non-traffic citations like disorderly conduct, loitering, Lovelace, harassment. Typically, those are convictions that will result in a fine. Those are the sorts of convictions that do not have to go downtown to the court of common pleas. The magistrates are able to impose fines or sentences for those. And then again, those are all expungible as long as you go 5 years without any arrests or prosecutions. So ARD is for first time nonviolent offenders. I will say the first time thing, typically it is for first time offenders. There's some discretion to the DAs where you've gone a long time without a case. Sometimes there has been a little wiggle room on that, depending on the nature of the offense. But it's not a conviction or an arrest. So it's not a conviction at the end of it if you serve the sentence first. There's some things you have to do to get into the program. It's at the discretion of the district attorney's office. Sometimes it can take a little longer to complete than a normal case because your speedy trial rights, you usually have to wait and participate in the program. And they do a record check to make sure that you don't have any convictions that you're ineligible. But again, your record is automatically expunged by the court once you complete ARD. And the big thing, both for ARD and for kind of expungements in general, so if you have outstanding fines or costs, that can kind of get in the way of getting your record expunged. So that's one thing that I'd have to make sure to get you paid, or if you have if you need relief in some sort of way due to like hardship, you can like ask the judge you had to waive those costs or fines for you in some circumstances. So how to get started? This link directs you to something we have on our website. It's an expungement quiz that kind of walks you through some of the stuff we're about to go over in terms of letting you know if you are eligible. It'll ask you some stuff about your record, about the end result of any charges you have, what the nature of the charges were, if you were in something like ARD. In terms of finding this, again, it's on the public defender's website for Allegheny County. I will also say, I think it might be on the last slide, but we also have an expungement petition guide, which kind of walks people through some of the stuff we're talking through today. It also gives copies of each of the petitions that you would need to file if you filed them in the courthouse. So that link also, that's on our website. So how do you find out if you have a criminal record? This link, UJS portal, .pcourts.us, that's basically the website where any of those public dockets I mentioned earlier live. So if you just type in UJS, it will bring you to the website. And then if you search by case, you can search by a number of ways, your name. There are numbers obviously associated with any criminal cases that will let you specifically look up a record. The easiest way to do it is use your name and your birthday, and search the criminal docket to see any whatever comes up. It will show you all of Pennsylvania, so it will show you Allegheny as well as other counties. Typically, the expungements need to be filed within the courthouse where they come from. If you can search for your criminal history, as it says here, search by name. It's important. The criminal docket obviously houses all the criminal cases, but some things that you can't get expunged, like those summaries, are going to actually be on the non-traffic docket, because that's where summary offenses that don't rise to criminal matters are. So you could miss some stuff that you actually could get expunged if you don't look at the right docket. So it's a little drop-down menu. It'll show you criminal and then non-traffic are the two that the court wants to check. So general rule for any expungement request or expungement petition is that you have to get a background check from the Pennsylvania police, and it has to be attached to the petition. At least in our office, when we do expungements for our clients, or when we do them for people, after we do like events in the community, we have certain agreements with the DAs about certain charges not needing to have those. They will waive the requirement that they be included for non-violent offenses. So that's one thing, one reason why it can be useful to try and contact my office about doing an expungement for you. We also, if you are eligible for us to do it for you, we'll waive the filing fee, which is about $230, or it might be $252. So that's another reason why I recommend if people at least contact our office to see if we can help you, because that'll save you about $250. So yeah, so that's but yeah, the background check, again, generally if you file it yourself, you're gonna need your background check. You go on it's called Patch, Pennsylvania, but you pay the $20. Usually they'll get back to you within 2 weeks or so. And then you have to attach that to a petition, again, unless you are eligible through our.
How long does it take to expunge?
As I said before, make sure all outstanding fines and costs are paid, because the statute specifically discuss the fact that those need to be paid before you are in the expunsion. I would say the most important thing here, let's talk about fines and costs. If you had some sort of resolution, like a summary or one of those convictions that can be expunged, restitution is always the most important, because that is money that goes to the victim in the case. Fines and costs also need to be paid, but those are ones where if you do have financial hardship, you might be able to file something with the judge to ask them to excuse those. Restitution is almost never going to be excused, because it's making the victim whole. Whereas fines and costs can, unless the fine is mandatory, the judge is allowed to take into account your hardship. They may be able to waive it if that's the thing that's impeding you. And if you have questions about that, that's something to talk to my office about it. So filing the petition is the next step.
I have a question.
Prepare the petition, you file it with common pleas. Again, you can't file it yourself. A lawyer or my office, if you are eligible, can do it for you. You have to do it for each arrest that you're trying to, each case basically that you're trying to get expunged needs its own petition. So it has its own case number associated with it. There are fees with that, as I said. I think in Allegheny it's about $250 to file the petition. It's put before, so the matter being put before a judge, it technically is, again, most of the ones, it's pretty rare that the district attorney's office objects to them. They're allowed to under the statutes, but my experience, it's going to be pretty rare that that happens. If they were to object to an expungement, you are entitled to a hearing with the judge, which would probably either be the motions judge in court or in the courthouse or Judge Rangers. So it would probably be one of those two. But again, as long as I've been doing this, which has been over a year that I've been in charge of expungements, I haven't had an actual hearing take place. So typically it's pretty routine. If granted, the board goes to the appropriate agency, take the appropriate action. They say here to take up to 9 months. As I said, I would expect maybe 4 to 6 is the average. It could be a little longer depending on how quickly each of those agencies obey the order. So on the PA Court's website, it has the petition listed there. There's a different one technically because they're under different rules for a summary expungement versus an actual criminal expungement. So they have different PDFs for those. I think those would probably also, if you look up like on the court website, the Allegheny Court website, we're in the 5th Judicial District, so it's probably on their website as well. This is what the forms kind of look like. This is a summary one, so it asks for your name, kind of just some identifying information. The case information, which could include the magistrate judge or the common pleas judge that you have. There's some stuff here about like the addresses of the magistrate office and like the name of the arresting officer and all that sort of stuff. Again, if you have questions about filling it out, you can contact my office. You can list the actual statute numbers and descriptions of what you're trying to get expunged, and then list the reason for the expungement, which is got to be one of those ones I listed earlier. Either I wasn't convicted of this, or it's been 5 years and this is a summary offense, or I'm 70 and I haven't had a conviction in 10 years. So this would just be kind of a place to put why you're entitled to this. And then there's a little checkbox for if you've attached your criminal history, or I have not attached it for a reason, and you say the reason. If you are going to file it, that criminal history has to be within about 2 months. So if you get it and then wait on it for 3 months, it's going to be out of date for purposes of the execution. So this is kind of form order from the court. So just you can kind of type in basically what you're requesting the judge to find. Essentially that again, these kind of being the reasons that you could list as to why you're entitled to an expungement. You kind of put in your information here, and then you leave some of this blank so that the judge can sign this down below. This is for the judge to fill out about now this day of whatever date. It's ordered that the petitioner, if they granted, that put granted, then that's.
Can I just make a comment here for the lay people that don't do this all the time? When lawyers or you, per se, put it in order for the judge, included in your motion, it's your suggestion of what the judge should give, like what you're asking them to give you. The district attorney, in like any other case, could also present an order. And their order would be say, this is what I expect from you. And the judge might make their own order, they might take that order, cross something out, circle something. So it's not like we just tell the judge, or the lawyer just tells the judge what she's gonna do. It's like you're making a suggestion to make her life easier, so she can cross one circle, put the date in, fill in, and think of it herself.
And then it won't be a finalized order until the court actually signs off on it, and then you'll get the actual signed copy.
I just think a lot of people are like, why would I tell the judge what you're supposed to say?
Yeah,
Like,
yeah.
are you supposed to tell me?
Yes, a good point. So this is again, if you're filing with yourself, when you go to file something with almost any filing you want to make, you have to make audit copies for all the parties. The district attorneys need a copy, the court administration needs a copy, judge needs a copy. So you have to sign the original, you have to make 4 copies, and then you keep one of those copies for yourself. So the original, and then 3 of the other copies are delivered. This is just the address for the courthouse downtown. Route 220 is the Department of Records. There's also a mailing address, and I think, like I said, that they can send this out to people if you actually need the addresses there. So clean slate, a little bit different from expungement, as I said, because expungement fully destroys any copies, even with criminal agencies, whereas clean slate just kind of hides everything from people who are not law enforcement agencies or like district attorneys or something like that. Specifically, this is 2023 law, expanded the expungement law to provide for automatic sealing of eligible offenses. That's kind of what they mean with clean slate, is the automatic sealing. Even stuff that isn't automatically sealed, you're still allowed to put in a petition to ask for it to be sealed, but there are certain offenses that are automatic, there are certain offenses that aren't, that you actually have to ask for.
So on the certain amount of time, how long is that?
Sir?
That I'm saying, it's a certain amount of time, how much time does it have to pass?
So, yeah, we're gonna get into that, particularly in the next session. So it's not available for certain types of offenses, which basically are any violent crimes that involve danger to a person, offenses against the family, offenses involving firearms, sexual offenses, and sex offender registration offenses, cruelty to animals, and corruption of minors. So these first couple, they just say offenses involving danger. The way that our criminal code is set up, there are specific chapters that relate to that. So like, if you look up your offense, you'll know if it's like an offense against the family because it's gonna be under a chapter that says offense against the family. So it's not like you just have to guess, does this qualify? It's gonna be under a chapter that says all these offenses under this chapter don't qualify. So things like some low-level drug and property felony convictions can be sealed if 10 years have passed with no convictions. A good deal of misdemeanor convictions can be sealed if you've had 7 years with no convictions. Then summary convictions are sealed automatically after 5 years with no current criminal charges. But again, if you have 5 years and with a summary conviction, it'll seal, but you should just get it expunged because it's much better and you'll be entitled to it in that. Yeah, so let's think the next slide. So low-level felony convictions which can be sealed after 10 years. Most drug crimes are shorter sentences. I think I have written down here specifically. There's primarily one felony drug offense that's the most common in Pennsylvania, which is a drug offense where the person possessed with the intent to distribute it or manufacture it or sell it, versus just having it for personal consumption. That's typically felony. And those are the low-level felony offenses that they're talking about with drug crimes. But there are felony thefts, including retail thefts, felony trespasses, felony forgeries, and criminal mischief. Criminal mischief is basically just like property damage. And then conspiracy to any of these crimes. All of those can be sealed after 10 years if you don't have a conviction in that intervening time. The misdemeanor convictions that can be sealed typically are any second or third degree misdemeanors. There's 3 degrees, and 1 being the highest, misdemeanor 3 being the lowest. And these are kind of the most common of the ones that are eligible: reckless endangerment, simple assault, DUIs, social conduct, all these. Terrorist threats usually is a misdemeanor 1. And there's a little bit of difference in how that would be handled. For any of these, even if the actual crime is something that could be sealed from public view, if on your record you just have, I think if you have 2 or more misdemeanor 1 convictions or above, or if you've got 4 criminal convictions, that could just make you ineligible for sealing as well. So the type of offense can determine if it can be sealed, but also just your record in general can also affect whether you're eligible for sealing.
Can I ask you a question on last one? Sure. So like a jailable traffic offense, like a G43B or a G43As, what is that coming for in, where does that land on the sponges?
So those are also summary offenses. So despite the fact that they have required jail time, any of the 5043s, at least the ones that you'd be dealing with, are still summary. You can get certain traffic offenses like suspended licenses, where if you get enough of them, they become misdemeanors. But they will have a grading when you go look them up. They'll say if it's a ungraded misdemeanor, which is just when it says M, or certain ones can rise to like higher, like misdemeanor 3, misdemeanor 1s. So it'll say next to it, whenever you look up any docket, it's gonna say somewhere on it, it's gonna say grading, and a letter, it says S, that's summary, and then the summary stuff applies. If it's an M or an F, that means it's a misdemeanor felony, and so those are usually the summaries.
So if it's not sealed or expunged, anybody can just walk into the magistrate's office and say, I'd like to see that. Police report or the
I mean, if it's not sealed or expunged, I can go onto the website and I can look up someone's name and it'll spit out what they've been charged.
Yes, it won't have the police report and all those things.
No, it'll be the conviction status, so whether it's been a conviction, dismissed, whatever, but it will show that there was an arrest or there was a charge. Those documents are, the courthouse has, but they're not like as accessible by the public. So I'm just talking about dockets, which if an employer types your name in, finds that you had a criminal case, looks at it, and even if you weren't found guilty, it says aggravated assault. They might just say, even if they were not found guilty, I'm not gonna give them a job. And so this is to kind of make sure. If it's not expunged or sealed, they can always do a background check with Pennsylvania State Police, which will show all of any charges that you've ever been charged with that haven't been expunged or sealed. That's typically what an employment screening will be, or like a housing screening. They will ask the Pennsylvania State Police, hey, can we do a background check on this person? And it'll say, these are all the things they've ever been charged with. And the only way to get those gone is for an expungement or if they're sealed.
But the only.
Oh, perfect. So next slide. So we can see law enforcement purposes, so police, prosecutors, criminal courts, gun ownership applications. Obviously, they want to know if you have anything, even if it's like a lower level thing. For immigration purposes, for international travel, other court cases may need them. Something like a family court might need them. If you apply to the bar as a lawyer, they will be able to see it. Limited situations with federal law, typically that's going to be if you apply for a federal job that requires a federal background check. So FBI records will show sealed cases, but they may be considered only when required by federal law. Part of that is just to say that the FBI is not bound by the court orders of like the judge in Allegheny County. So sometimes they will still have certain things that are sealed, but they can only really disseminate those in specific circumstances, usually when there's a federal background check involved. So that's just something to be aware of. How do you get your record sealed? So there's kind of, like I said before, some of it is automatic depending on the type of charge. If it's not automatic, then you can still file a petition with the court and ask them to seal it. That's a little bit more of an expanded list. It still doesn't let you do those like violent crimes, sex crimes, that sort of stuff, but it does allow for slightly more serious crimes and some felonies. Those are not automatic unless it's a drug felony, but you can actually file something with the court saying, hey, this felony is old, it's not violent, can you take it, or can you seal it? So expungement versus sealing. Sealing is a process where they are sealed so they can't be viewed by the public. Difference from expungement, which removes it from a record entirely, leads to like law enforcement and state licensing agencies being able to destroy it versus sealing means they can still use it. So if your record's sealed, can you access your own court documents? Yes, you can, because they're not actually destroyed. So sealed case files are simply unavailable to the public. They're on that limited access doc that I talked about. The courts can still see it. So you can request your own court records, even once it's sealed, if you go to the courthouse where it happened. So that way, if you do need the information for FBI purposes, for immigration purposes, for international travel purposes, it still exists somewhere. That's why if it's sealed, that's why those places can still get it. If it's expunged, just treat it as a record. So other similar procedures that aren't exactly the same area, as I said, you kind of just do the sentence first, typically probation. And if you successfully complete, then they will automatically expunge it for you. Section 17, that would be pretty sure it's referred to the probation without verdict, which is a similar thing. You get probation, and if you complete it, then the case is actually dismissed against you rather than a conviction against the record. And then pardons, so that's asking for forgiveness, can only be granted by the governor. Lengthy process, it's not sufficient to describe it. It's usually like probably 2, 3, 4 years from the filing of the petition, because they get so much volume. The board of pardon, or the pardon board, they have a website you can submit your applications to, and they kind of review them for the governor before they put them on their desk, and they decide whether or not to grant. So that is equivalent to you have never been found guilty, but they're quite ready. So again, key point, pay fines, fees, and restitution, because almost always that's going to impede you being able to get the expungement or sealing approved. So do that as best you can. Again, if there's some issue, you can try to either reach out to the magistrate courts like Pittsburgh Municipal Court, or if it was out of common pleas, you can try to file a motion with the judge to see if you can get those excused. Otherwise, you got to get them before they're going to approve the expungement. And here's that slide that has some resources. Philadelphia Lawyers for Social Equity, they have stuff that they have resources to help people in the state, but the petitions actually just are for Philadelphia, because again, it's about, you have to file it within the county that the case came out of, but we can, as I said, we can help people in Allegheny County if they have questions. Legal services, Pittsburgh Bar Partnership, Pardon Hub, the Allegheny County Bar Foundation has some people who can help out with that. And then again, there's just some links. There's a voter process guide that I was talking about earlier that has answered some of these questions that I've gone over. It also has a copy of each of those different petitions that if you wanted to file yourself, you could. The only thing I will say is about my office is that generally, because we have that agreement with the DAs about waiving the background checks for certain things, there is a limit to how much we can help with partial expungements. We can do full expungements. We can help you with partial expungements. We may not be able to file the partials for you. So that's just one thing to be aware of. But full expungements we can do, summary expungements, and then we can also answer any questions, help you prepare the. We have some resources to help prepare the petition if you can't do it.